today's discussion will look at how current H-1B rules, enforcement trends, and the proposed changes affect workforce planning, budgeting, and compliance decisions for employers moving into 2026 and beyond. I'm joined today by Serge Boheme, Managing Partner at Polatsek Boheme Wilkowski. Serge advises employers nationwide on business immigration matters, including H-1B strategy, compliance, and long-term workforce planning. He works closely with human resources professionals, in-house counsel, and corporate leadership to navigate both the ongoing sponsorship needs and broader policy shifts. So Serge, welcome.
Thank you.
We've got
nice to see you again.
Likewise. We've got several questions that have already come in by email, and we're going to begin with that series of questions. So let's just begin at the beginning, talking about the fee scope and the financial impact. We're all aware of this new $100,000 fee. Does the new fee apply only to new H-1B petitions, or could extensions, amendments, or transfers be affected as well?
Excellent question to start with. This is a question that has naturally caused a lot of understandable concern, because early reporting and informal comments suggest that the fee might spill over into renewals or even ongoing populations. The most important practical update I could give at this time is that USCIS guidance has narrowed it. It has narrowed the $100,000 payment to a much smaller subset of cases than what many employers initially feared. The current best understood scope, based on the post-proclamation guidance and public summaries of USCIS clarifications, suggests that the $100,000 payment is tied to new H-1B beneficiaries who are outside the United States. And it's usually mostly at the time that the petition is being decided, or where it's determined how the person will come in. It's a nuanced distinction that I'll get into in a couple of minutes. But basically, it's treating it mostly based on the concept of the entry-related condition. As you're going to enter the U.S., based on this, is it based on you're already here in the country and an extension or a change of status is approved, or are you going to be in a situation where you have to enter the country subsequent to the petition to start the H-1B. By contrast, in-country filings, think of extensions, amendments, changes of employer, filed for individuals who are already in the U.S. or changing their status, have generally been described as petitions that are not going to trigger it so long as the Immigration Service approves the part where you're requesting to be allowed to remain here in the States. So the key concept to understand here is the difference between an in-country extension of stay, which can happen through an extension of status petition or a change of status petition, and an out-of-country entry case. As mentioned before, this is a nuanced distinction that doesn't necessarily depend exclusively on the way that you present the initial request, but rather on the end result after the petition is adjudicated. Of course, how you request a petition initially will determine in great measure how USCIS will adjudicate it. But if USCIS later determines, for example, a failure to maintain status, then it is possible, if not likely, that the fee will trigger to the case, because this will require an out-of-country entry. So if you're modeling exposure, the highest risk bucket is new cap hires or new H-1B beneficiaries abroad who will need consular visa issuance and entry. The lowest risk bucket is if you're an existing H-1B population when you're filing routine extensions, amendments, or transfers from within the U.S. And then, of course, the follow-ups would be if you're filing petitions for people who are here in the States and you're just merely changing their status. So a few things that employers need to flag with regard to all of this is that new is not really referring to the form type, but really more about the worker's posture. An amendment for someone who's already had an H-1B is not the same risk profile as an amendment for someone already working here. So really, the choke point in here ends up being the necessity to have consular processing to be able to enter. in most of the cases. If you're Canadian, you don't need consular processing, but you're still going to have to leave the country and come back. So even when the fee does not apply at the time of entering, filing the petition, later on they may determine that it's going to be required. Now, with all of this, it's very important to understand that policy can evolve fast. The guidance I'm giving you guys today is materially narrower than the early speculation. That's the good news. The bad news is that employers could still treat this as a live compliance area and avoid last minute filings when possible, because these things, it's a fluid situation. It may change at any moment. Bottom line, with the latest clarifications, the $100,000 payment is best understood as primarily affecting new H-1B beneficiaries abroad rather than routine in-country extensions, amendments, transfers, but employers should keep scenario plans ready in case interpretation shifts or in case things happen at the time of adjudicating the petitions for people here in the country. The main thing really to look out for that is have people been maintaining status? If you have an issue with the maintenance of status part, then that may end up triggering the $100,000 fee, regardless of how you presented it at first. Again, with all of this, usually the best advice is early planning. So, in general, one of the biggest mind shifts that employers need to make with all of this is that status mistakes no longer just cause an inconvenience. It used to be that if you had failed to maintain status, it's not the end of the world. We'll apply for it. You can continue working for the company while the extension petition is pending. And then later on, if the Immigration Service denies the extension or the change of status part for failure to maintain status, no big deal. You would leave the country and go get a visa and then come back and resume your H-1B status. That's no longer the case with H-1Bs. They can trigger extraordinary costs right now. So it's very important that you make sure that your employees are maintaining status, pay them the right salary, make sure they're working in the right position, that they're getting the correct salary as per what was listed on the LCA and the petition. And make sure that it appears so as well. Sometimes companies are truly employing people in the position that they mentioned that they would, but on LinkedIn or business cards are different. They may use an internal title or something that might be different that could trigger different understandings as to what's really going on. And any failure to maintain status right now could end up being an extraordinary cost. So in today's environment, preserving clean in-country continuity is one of the most valuable immigration strategies you can have. Let's prevent rather than have to deal with it on the back end.
Great advice. So, Serge, how should finance and HR model immigration costs for 2026 if multiple regulatory outcomes are still possible?
Well, I would say that the traditional idea that we've had of a single immigration budget forecast, it's out the window. You cannot continue doing things the same way. That approach is just no longer realistic. Instead, I would recommend finance and HR to build, I would say, 3 parallel cost scenarios. There could be what they call a status quo continuation scenario, where the current fee structures will remain with modest increases. But you should also consider moderate expansion budgets with higher fees applying to most H-1B filings, plus increased compliance costs. There may be more audit reviews, and doing that can cost money. There may be a lot more RFEs than they had expended projected before, and that takes a lot of time. And then there's the high impact scenario. As time is going on, you should expect expanded fees, increased RFEs, longer adjudication times, and higher legal spend. All of this is going to require additional work. What often gets missed are the indirect costs with all of this, though. Delayed onboarding, lost productivity, internal HR time responding to government scrutiny. These are costs that rarely show up in the immigration invoices, but they materially impact the business. You should be ready for all of those things. Early planning can make a big difference. I would say that the most sophisticated employers in this regard are going to treat immigration as a risk-adjusted investment, not a fixed expense anymore. You just cannot afford to do that.
Oh, excellent. Well, we have a couple of questions on strategy, competitiveness, and workforce planning. So let me dive into the first one here. How does the new weighted H-1B selection system affect the competitiveness of roles?
I would say it's gonna set it in its head. It's gonna change things dramatically. Right now, this requires a lot of earlier planning on how you're going to present everything. The weighted selection system changes the competitiveness of roles in a very specific way. Pushes employers to think in terms of wage level positioning, not simply paying more. That's different. That's a very critical distinction that people need to understand. Under the final rule and agency commentary, selection preference is generally anchored to the Department of Labor's four-tier wage level framework, which is tied to the occupation and location. They have four levels, levels 1 through 4, rather than a free-form notion of salary alone. So in practice, that means two roles could have different selection odds, even if the total compensation feels high for both of them. Because what matters is where the offered wage sits relative to the prevailing wage distribution for a specific SOC code and metropolitan area. So when we talk about strategy, I'm not advising companies to throw money at the problem. I'm advising companies to deliberately design roles so that the wage level outcome accurately reflects the role's true seniority and complexity. So there are employer levers that can legitimately move a position into a higher wage level without artificially inflating a salary. That's a dangerous thing to do. You're going to get caught if you do that. The Department of Labor and USCIS, they know what they're doing, and they're going to be looking out for things like that. So I would say that you need to pay attention to the role architecture and requirements. That's the biggest part. Wage levels are heavily influenced by the role's required experience, specialized knowledge, autonomy, and responsibility. Tightening the job description to reflect real complexity, advanced domain expertise, independent judgment, system ownership, or cross-functional leadership often supports a higher level. If level 2, the second item would be supervisory and scope of impact elements. If the role truly includes leading projects, mentoring juniors, or having decision-making authority, documenting that can clearly align the role with a higher prevailing wage tier. Then there's the correct occupational classification. A misclassification is very risky, but underclassifying a role is also a strategic mistake under a weighted system. Getting the SOC code right and choosing between closely related codes where appropriate can materially change the prevailing wage benchmarks. And then there's location and worksite strategy. Prevailing wages vary dramatically by geography. If the business can legitimately place a work in a higher wage area or restructure hybrid arrangements consistent with compliance rules, wage level positioning can shift dramatically. So all of these items, there are things that can be considered at the time of presenting the wage level, which will change to a great extent the chances that your petition will get selected, but also the wording of the position itself. But as I mentioned before, the USCIS and the Department of Labor are very attuned to gaming. Any attempt to elevate a wage level must be supported by real job factors. They must remain consistent through the registration, the LCA, and the petition narrative. If the role is truly entry level, forcing it into a higher wage level creates downstream RFE and compliance risks. Don't do it. Start preparing from it early on. I would say the key takeaway from all of this is that the weighted system rewards employers who can accurately demonstrate that a role is higher skill, higher complexity within its occupational wage framework. The winning strategy is often job design and classification discipline, not simply paying the highest salary. All of this is going to require strategic planning, so I would recommend you start working on that yesterday, if possible.
That's great advice. So, Serge, could these changes push certain roles offshore or require some type of adjustments to global staffing strategies?
What we're seeing is not a wholesale shift offshore, but rather a rebalancing of where work gets done. When immigration pathways become more expensive or unpredictable, companies often respond by relocating functions, not people. This might mean building complementary teams abroad, adopting hybrid staffing models, or increasing reliance on short-term assignments rather than permanent U.S. placement. The most effective global strategies are intentional, they're not reactive. Employers that integrate immigration constraints into workforce planning early are far better positioned than those making last-minute adjustments after petitions fail.
Let's talk about maybe some alternatives as well. Are there any current H-1B employees or candidates who are eligible for visa categories under existing rules, like, for example, the blanket L?
Right. Excellent question. And the short answer is yes. And this is often an underutilized opportunity. Many employers focus exclusively on H-1Bs without fully assessing whether employees already qualify for alternative classifications. The L1 category, for example, particularly under a blanket L program, can be a powerful option for employees who have worked abroad in managerial, executive, or specialized knowledge roles for multinational organizations. The key is conducting an early and honest eligibility review. Waiting until an H-1B fails or expires usually limits your options. So employers who proactively map their workforce often discover viable alternatives already exist. The key again to all of this is early planning.
Yeah, early planning is the core theme here. So how would an employer know whether they already meet or could quickly meet the requirements for programs like a blanket L that reduce the reliance on H-1B cap?
Well, again, this is where preparation can make all the difference. Blanket eligibility depends on company structure, revenue thresholds, and consistency in role classification. Companies that already maintain clear organizational charts, clear reporting lines, and standardized job descriptions are often closer to this than they realize. That said, the blanket L is rarely a same quarter solution. It rewards companies that invest early in documentation and alignment. The organizations that benefit most are the ones that treat global mobility as a long-term capability rather than a short-term fix. Look at this in the long picture.
Yeah. And speaking of time frame, as well as risk and decision making, we have some questions that fall into that category. What are the risks for waiting for litigation or regulatory clarity before taking action?
Good question. I would say that litigation almost never moves on the same timeline as business needs. So while lawsuits may eventually clarify or delay implementation, employers who often wait miss filing windows, lose candidates, or face higher costs when rules finally take effect. Immigration policy changes tend to apply prospectively but abruptly. The safest approach is contingency planning, filing when possible under current rules while preparing alternative paths if conditions change.
Yeah, that makes sense. And what if enforcement or policy changes occur, say mid-year? How quickly would a company need to be able to adjust their workforce plans?
Well, unfortunately, sometimes in many cases, it's going to be immediately. USCIS and the Department of Labor, their enforcement shifts can change adjudication standards overnight. Companies need internal processes that allow for rapid role assessment, alternative visa activation, and hiring timeline adjustments. Agility is no longer optional. Employers that succeed are those with pre-approved contingency plans, not those scrambling to interpret guidance after it's issued.
Absolutely. And so, what decisions should a company be looking to make this year to avoid being locked into a higher cost or a less flexible visa option for next year?
Well, I would say that this year is about preserving optionality. That means accelerating green card sponsorship where appropriate, filing extensions earlier rather than later. Really, please remember you can file most extension requests as early as 6 months before. So start working on it 9 months before so that you can file it on minute one. And then also avoiding over reliance in a single visa category. Decisions made today, especially around role structure and sponsorship timing, can significantly limit or expand choices in future years. So again, start planning early, start looking for the options, start doing everything earlier than before. You may avoid things that may disrupt the ability to keep that employee. Early actioning is key with all of this.
We've got one last question. It's on compliance and preparations. Serge, are there compliance documentation or job structure steps that a company should take now to preserve the flexibility later?
Absolutely. And this is one of the most overlooked areas. Consistent job descriptions across immigration filings, HR systems, and payroll records are critical. Clean documentation is not just about compliance, it directly affects your ability to pivot between visa options. Well-organized employers move faster, face fewer RFEs, and retain far more strategic flexibility. Today's environment, compliance is not a defensive posture, it's a competitive advantage. One message that I would leave you with all of this is that immigration success today is less about reacting to rules and more about designing systems that can adapt those rules as the rules are changing.